Ever hear someone say, I'll test the market first, then I'll think about getting a patent later? Well, think again. Hi, everybody. I'm JD Houvener, owner, founder, and patent attorney here at Bold Patents Law Firm. And I get it. A lot of people just want to get out there and see if someone wants to buy their product. They want to build it and hope that they will come. Classic. But you want validation, and there's nothing wrong with that. It's just the timing is important. Here's the truth. Testing without protection risks handing the idea away, giving it away. You could lose the ability to protect it if you do not file a patent application. If you put in money, time, effort, really expensive to do injection molding, finalize the design, get it all packaged and put it on the shelf, that could take months, if not years, or someone else could beat you to the patent office. Someone else could file for a patent, and all of a sudden you're infringing. Ouch. Don't make that mistake. Okay? So shift your perspective from, I need to go test this quickly, to let's protect, then test. Those are the order of operation. Testing is fantastic. And done the right way, you can file, for example, a provisional patent application, allowing you a whole year to do just that, to test the market, tweak the design, get it just right, and then file the non-provisional full utility application, claiming the exact product that's selling. So done right, testing is the right path. It just must come after getting that provisional or some patent application filed. Here's some examples. The fidget spinners. These things went viral. They were everywhere and still are someday. The original inventor had let her patent lapse. And so the whole world profited without it. The Snuggie, you probably heard of the Snuggie. This succeeded because the company protected the design before mass marketing, shutting down lots of knockoffs. Now, they didn't have to go hire their own lawyers and go through federal court all the time. They were able to use the third-party retailers like Walmart or Amazon. They went to bat for the company because they had the federal rights. Third example is Hydro Flask. You guys probably have these water bottles sitting in your cupboard. Their founders patented their double wall vacuum design early, then hit the market with confidence. Their IP kept imitators at bay until the brand exploded. So the difference wasn't the idea, it was the timing of protection. So don't get your timing wrong. Schedule a free discovery call with Bold Patents today. Go to boldip.com, schedule your discovery call today. I'm JD Houvener, wishing you guys a great day. Go big, go bold.